Man. All right.
Okay, good evening, everybody. South Florida Hospital News with Mirza Healthcare Law. This is a continuing series of legal issues, primarily for physicians and people with and healthcare professionals in the more physician space. We do this every month, usually about the third Tuesday of the month, as it is today at 6:30. So it's a continuing series. The series is going to be recorded. If you like anything or you missed anything or whatever, it's going to be recorded and picked up off my website, probably within a day or two. It'll be posted on the website. You can look for it under legal webinars or webinars listed on my website. And with that, I will turn this over to Ben, and Ben can go ahead and give you the legalese and getting started with this, and then start the program. And thank you for being with us tonight.
Thank you, Charles. Thank you for the opportunity to present. It's nice to be with you guys this evening. So the only thing between you and a meal is really me. So I'm holding you guys all back. So I'm going to try to make this as quick and informative as possible. So let me start the screen share. Screen 2. And can you see that presentation?
Yep, all good.
So slideshow. All right. So as Charles said, my name is Ben Mirza. I'm an attorney. I've been an attorney for about 21, 22 years. And I'm formerly a CPA. I've worked in like some major companies, including in-house general counsel for like Broward Health or Health First and American Medical Depot and a few other places. So I've got a fairly varied background in healthcare, and today it's going to be primarily me speaking. Another gentleman who is my colleague is Ed Meyer. He's usually on with us, but tonight he's got other stuff going, other obligations, so he's not here today. But he's another very, very learned individual. He has been practicing healthcare law for about 30 plus years, and he's actually just a great resource for all of our clients, as well as myself. I turn to him to ask him for certain things. My experience was that in litigation, he is really a highly technical healthcare law expert. So whenever there's something very quirky, I always join heads with him to figure that out. So today's presentation is going to be about how to avoid lawsuits from the bedside. And what I did in this presentation is I also inserted the part about how to avoid complaints, and we'll walk you through the complaints process. And the reason why we want to talk about this is because when it comes to lawsuits, a lot of physicians don't understand how lawsuits work and how they can work against them if they are ever involved in a lawsuit setting. So with that said, let's get started with like market forces. When it comes to actually market forces, it really matters to a patient what a physician's bedside manners are. You will not believe how many patients will leave a physician only because they had a bad interaction with them. If you look, so the way a physician treats a patient has a huge difference in their business. And also, I think it has a difference in the patient's health outcomes, because then they listen to the physician a lot more. And the more friendly that patient is with a physician, I think the less liable you're going to find yourself in the long run as a physician, because people don't like to sue people that they actually like. So that's a way to avoid it. So today's presentation, we're going to start off with do's and don'ts of medical practice, the types of liability in cases that are involved that could be posed, the medical complaints and the disciplinary process, and then we're going to walk through how the lawsuit process works and what to look out for, how to stay alert, and how to know that there's a lawsuit coming. So when it comes to actually do's and don'ts of practice, the first and foremost reminder is talk to a patient as if you're eye to eye, one-on-one, very close sort of an interaction. And then what you want to do is make sure that you're taking care of infection control in your office, that everybody's washing hands, putting on gloves, not touching ties and pens and iPads and tablets and going back and forth, you know, because that could be that could be something that transmits infections. Keep in mind that you also have a team approach. So be like Disney. You know how Disney actually has a front game face, and then in the back they're doing all of these things to make everything in Disney happen. Well, much like that in a physician's practice, if something doesn't go right, make sure that in front of the curtain you're taking care of things in a very professional way. If you've got to take corrective action, make sure you do it behind the curtain, meaning in private. The other thing to keep in mind is confidentiality. When it comes to patient-physician relationship, there is a confidentiality issue, right? So when you talk to family members, just make sure that your patient is okay with you talking to their family, giving them detailed information about their health and so forth. So that, you know, that's something to look out for. Then also be approachable. Be approachable. Listen to your patients. Listen to your staff, because they will tell you what's coming up. Patient history. You won't believe how many physicians will walk into a room without reviewing the actual history when they know they really should have ahead of time. So read the charts, read the reports, read the incoming tests and so forth that have come in from like the labs and so forth, and it'll make you a much better physician. And then take timely notes. The more timely you make your notes, the more accurate it's going to be. And don't just rely on cutting and pasting, because a lot of physicians do cutting and pasting, and that helps. But you got to just remember to make the notes accurate. There are times that you will see things in the notes that look like a complete cut and paste job, and even wrongful notes can be pasted in there.
Ben, I got a question for you on the note situation with a doctor. How much time could pass before you should go back and see if there's a correction that needs to be done before you're turning it over to another physician or something like that? Is there a time period you can kind of get
you know, most places require you to actually turn in your notes within 48 hours. But then you know, once you submit your notes, most systems timestamp that, and if you've got to correct something, you got to correct it in like an appended, like a appended note to it. Typically cannot go back in and you know, change the notes that you had in the system. And maybe some systems allow it, but I'm not familiar with those.
Okay.
The other thing to keep in mind is your patients, when you give them a prescription, to provide them an explanation, tell them what the purpose of it is, tell them what the adverse effects are. You know that the pharmacist always gives them like an advisory piece of paper that has that stuff on it, but still they're not really going to read it. So you need to actually give them what a prescription is for. I think it's greatly appreciated, especially by the elderly who, you know, who have a hard time reading anything and doing, you know, they just need help. They need extra help. Also keep in mind that your Disney experience begins from the front desk to the medical assistant, to the physician, and then all the way out to the exit desk, right? So the exit desk, that's a whole Disney experience that you got to think through, and you got to think through each process and how is a patient being treated in each of those steps. When it comes to money can obviously raise some feathers, and you've got to make sure that you're clear and as precise as you can be about their co-pays and their financial responsibility with your office. So, you know, oftentimes people become disgruntled because they feel that you're charging them more than what they were expecting. Now, keep in mind, some patients do threaten their healthcare providers with violence or with lawsuits. If they do either of those, I always tell my clients to actually fire the patient. Just get rid of them. You don't need a threat of violence, and you don't need a threat of a lawsuit. Just get rid of them. Keep a template handy. If you don't have a template, email me and I'll email it out to you. Email me and I'll send you a template. But you can also Google it. They're readily available. Keep in mind that in Florida, you have to give them a 30-day notice. And you don't have to necessarily state the reason. If you want to, you can. But you don't have to state The reason I would even go as far as telling them, hey, go and contact like Broward County Medical Association for a referral, or go back to your insurance company for who you should go to next. Something like that. But remember, fire fast. If you've got any threats of violence or lawsuits, fire fast. Now let's talk about medical complaints and the disciplinary process. Well, before I go on, any other suggestions that you guys might have in mind in terms of typical do's and don'ts, what to do or what not to do in a medical practice? Anything unique you guys do in your practice? Joe, Louis, Charlene? Okay. All right, just checking. Joe?
Nope, nothing for me.
Okay. All right, let's talk about the medical complaints and the disciplinary process. And I think all physicians should be familiar with this, or at least familiarize themselves with it, which is the common disciplinary actions really come from the medical records reproduction. So if a patient is asking for the medical records and the medical office is not turning over the records, they really should, and they should do it readily and quickly, and just make them available. Listen to your patients. You got to get it to them. The other thing is, what I've also seen is illegal prescriptions. So like a physician will prescribe, controlled substances without having done the accurate, like the specific checks that would qualify the patient to be able to get that controlled substance. So there is such a thing as illegal prescriptions, and that can become a common sort of a disciplinary action. The other thing to keep in mind is adverse incidents like wrong site, wrong person, wrong procedure. Instead of the left side, it's the right side. And also, if you move your office, make sure you actually update your practitioner profile. Believe it or not, when the Department of Health investigates in a particular complaint, one of the very typical things they'll look for is what's your address. And if that's not up to date, they'll ding you for 2 complaints. Not only the complaint that came in, but that you didn't update your profile. So they'll ding you for 2 things. Also keep in mind patient boundaries, right? So just know how to, just be mindful of the fact that you may be coming across inappropriately to a patient, whether it's language or whether it's the way you touch somebody, or whether it's what you say and in the context that you're saying it. When there is sexual misconduct, so to speak, there is actually 0 tolerance from the department on that, and that's considered a Category 1 offense, and it's looked into swiftly and harshly, and that person gets written up fairly quickly. I've gone through a situation where I represented this one practitioner for them touching the small of the back of their patient, and that's kind of how it ended up. They got written up for it, and it went to the state, and they got reported, and they had to deal with all that, right? So touching the small of the back as they were walking them. So be careful of that.
And question for you, Ben, on a physician, in a physician record for the state, you have 2 addresses. You have a mailing address and you have a location address. When you talked about the moving address, so when you update something, if you move your mailing address, you have to change it. If you move your location, you have to change it. And if you have multiple locations, you have to report all locations.
I don't think so. I think you just have to actually keep one primary and one mailing.
Okay.
I don't.
But both of those have to be current.
On that.
But both of those have to be current, or you can get kind of.
Yeah, both of those have to be current. Both. Yeah, definitely, including the mailing address, because that's really their only way to contact a practitioner.
Okay.
So who typically files a complaint? It's usually the patient. Sometimes it's actually a disgruntled employee. It could be other physicians. It could be a competitor, or it could be just random enforcement issues that come up. And sometimes you're even required to do like self-reporting. So like, for example, a self-reporting thing would be something like a physician or a practitioner gets pulled over for DUI, and then they get prosecuted for it, and they're found guilty. or they plead no contest and they didn't report it back to the state. That's considered self-reporting if they don't report it back to the state, because if the state doesn't know about it, if they come to find out about it on their own, that action that they take from that would be much harsher than the self-reporting. So you gotta make sure that you're self-reporting when you need to. The common complaints again are not updating the medical records, medical records reproduction, adverse incidents, and sexual misconduct. By the way, over here to the left, as you can see, this is like what that form looks like, the Department of Health complaint form. So what does the department do when they get the complaint? So the first thing they do is take a look at whether it is something that they can regulate. If it's just an issue regarding payment or regarding customer service, they'll tell the person to go back to actually the office manager and talk to them. But if it's the actual healthcare professional doing something improperly, they need the complaint to be in writing. It has to be signed by the person who's filing it, and they must allege ultimate facts that a violation of law or practice or the rules has occurred. If they don't, it's not considered legally sufficient. So these three things have to be there. Once it's deemed legally sufficient, then the investigators may then request further documentation to complete the investigation process. So what happens in the investigation to a professional's rights? So when an investigator steps in, most healthcare professionals have 20 days to respond. But if you're an MD or a DO, you have 45 days to respond. And then in the end, the Department of Health will do their investigation and they will do the conclusion. They will then either refer the case to prosecution or refer it to a probable cause panel. First, actually, it'll go to the probable cause panel, and here's the diagram that the state has up on their website that the complaint follows. It comes in through here on the upper left-hand corner where you see the word complaint, and then it follows the process all the way through until it gets to the probable cause panel. And let's talk a little bit about how the probable cause panel, well, I'll bring that up in just a minute. So what happens with the complaint? So then the complaint is either dismissed. There could be a minor citation issued, like, for example, in the case of addresses or phone numbers not being up to date, or it could be referred to mediation if there are certain facts that are disputed and you just don't think that something should be taken as harshly, or it could be referred to further investigation and assembling of even more information. And then once they assemble the information, what'll happen is that it'll go to a probable cause panel. The probable cause panel has on it usually about 5 members. 2 of them are from the regulatory board, 2 of them are licensed healthcare professionals, and 1 of them is a consumer member. So this is how the probable cause panel is set up. So the probable cause panel will take a look at the facts and the findings of what the investigator came up with. And then what they'll do is they'll recommend either a further investigation, or they will dismiss the case, or they will issue a letter of guidance. Now, on certain cases, they will go back and refer the case to prosecution. That's if they find probable cause for prosecution. So what'll happen next is that the Department of Health has attorneys inside it. They're actually enforcement attorneys. So they will take the complaint, they will send it out by certified mail to the practitioner's office or to their mailing address and serve it. From that point on, that practitioner has 21 days to select the type of hearing they want. There's 2 types of hearings that are allowed. One is an informal hearing and one is a formal hearing. Informal hearing is for really legal disputes, but where no material facts are in disputes, right? So it's the law that's in dispute, but not the facts. Then in a formal hearing, it's really both. You're disputing the facts and the law. And that usually goes before an administrative law judge, and that's how the hearing process happens. Now, going through the formal hearing process can be very costly and expensive for a physician, which is why I think you guys are here. And it's important to actually go through this process and understand what you're doing. The informal hearing process is still fairly expensive, but not as expensive as the formal hearing process, because the formal hearing process is treated much like a case, but it moves really fast. So what happens next? So if there is a case that's filed, you are able to do discovery. You're able to actually depose people. You're able to depose the witnesses. You're able to depose the actual person that's making the allegations. You can serve subpoenas, provided that the judge signs off on it. And then what you do is, once you've gathered all of that evidence, then what you do is you proceed to hearing. So the prosecution has the burden of proof. They have to show clear and convincing evidence in order for them to revoke a license. But if it's just to like issue a warning, they just have to do the greater weight of the evidence, right? If there is no revocation of license, it doesn't have to be clear and convincing. So remember, those thresholds of burden of proof will play into this. And depending on what outcome the prosecutor is looking for, that's the level of burden of proof that's going to be required. If you're actually looking to revoke somebody's license, it's going to require a much, much higher level of proof. Well, also these hearings are held much like a regular bench trial would be, like in regular court. So what are the possible outcomes or penalties, right? So somebody can either get suspended, or there's a permanent revocation. That's possible. You can have a restriction placed upon your practice or your license. People can be fined up to $10,000. There could be as simple as like an issuance of a reprimand. There could be a probation period. It could be 10 days, or it could be a year. There could be corrective actions. Maybe the person has to go and take some remedial education stuff. The professional will also be asked to pay for the cost of what it took to investigate and to prosecute that case, and they do assess the cost onto the actual defendant. Now, but if the case is dismissed, then the person is entitled to attorney's fees under Florida Statute 57.111 for unreasonable government actions. So keep that in mind. If you're gonna fight all the way and you do get that case dismissed, you are allowed to apply for attorney's fees. Potential ramifications of an adversary decision, right? So what happens if you get an adverse decision placed against the professional? So first and foremost is the NPDB, the National Provider Data Bank, right? So it'll get reported in there. And once that happens, that triggers a lot of other things. You could lose payer contracts, you could lose hospital privileges, you could lose reciprocity with other states. It'll have to get reported also to the other states. You could be excluded from certain governmental programs. Your liability insurance could go up. You could have potential DEA action against you, depending on what the violations are. So the ramifications can be significant outside of the actual disciplinary process. So assume that the whole disciplinary process has happened, and something happens, and a adjudication is had against the professional. These are all of the other things to like look out for. Plus, you can have a loss of a specialty license too. So keep in mind, but if there's no error or mistake found, remember you can recover attorney's fees. Now, if you don't like the decision made by the administrative law judge with the Department of Health, you can appeal that decision, but you have to proceed to District Court of Appeals and file that promptly. If you don't file it promptly, you lose the right to appeal. So if you ever do get a decision made against you that you believe is wrong, then proceed to like District Court and move the case along. Any questions about the disciplinary process? Okay. Now I'm going to talk about professional liability claims and the litigation process, which is a little bit different. So first of all, you want to keep an eye out for medical malpractice claims, right? So these are the hints. Number one, you're looking for threatening patients. If a patient threatens you, that's a hint. Remember what we talked about, fire them. Fire them as your patient. If a lawyer requests to meet you in person, meet the actual physician, that may be just the lawyer inquiring as to what the physician did or did not do. If they request medical records, which is often usually a very common thing, but from time to time, if you have a problematic patient, it may be because they're looking to take some sort of legal action. So keep that in mind. That's how you know what's coming. There could be a complaint filed against a physician's license, and sometimes that's the prelude to an actual lawsuit. And if you get a letter of intent to sue, that's an obvious statement. They're actually telling you, hey, I'm planning to sue you.
So Ben, from the last part of your presentation, that could be the prelude to a possible medical malpractice claim. Is that correct?
Yeah. So yeah, I mean, I would venture to guess that there's a pretty good correlation between a Department of Health license complaint to the actual malpractice. So I mean, there's got to be a correlation to it. I don't think anyone has done the statistics on it, but I'm sure it's there. Because I can see an attorney saying, go and file this complaint against your physician first. Let's see how that goes. If there's an adverse decision that comes out, then you can see, a medical malpractice sort of a lawsuit coming up after that.
So in other words, if you get cleared by the first process, you could still get into a med mal claim after that.
Well, it could, yeah. And if you get actually found for doing some sort of wrongdoing, I think your chances of getting a med mal claim go up.
Right. Okay.
Kind of obvious. So yeah. So what kind of lawsuits can be filed, right? So typically it would be deemed a negligence, like a negligence count. And it would be for things like failure to respond to emergency calls, failure to respond to certain sorts of requests that were being made, like maybe for a particular sort of a medication or the wrong medication, or this medication isn't working for me and the physician fails to actually respond. There could even be misdiagnosing something. There could be a delay in diagnosing, like for example, if the results from a test or a lab or a scan come in, and then the physician doesn't get to it for a few months, and they haven't looked at it, and in the meantime that disease progresses, that's a significant delay in diagnosing, depending on what sort of a disease it is. So these are the kinds of claims that typically come up. Failure to refer, like if you're a primary care physician, why don't you refer out a cardiology matter to a cardiologist, right? So those kinds of things can come up. Lately, infection and contamination has become obviously a big issue with COVID-19, and there's a lot of lawsuits in that area. So lack of documentation can actually exacerbate that situation, and it will, obviously in like negligence claims. So what's a lawsuit? A lawsuit actually starts with a process server. The process server will typically come in and knock on a physician's door, like literally like knock on the door, and then serve a complaint. And then from that point on, the physician has 20 days from the date of service to respond to that complaint. So what's a complaint? A complaint is really a short and plain statement of facts of the basis of what the patient is saying that the physician did wrong. And usually the patient is the plaintiff. And if they pass away, their heirs have the right to become the plaintiff. So if it's a wrongful death claim that falls under medical malpractice, the estate of that patient can file a complaint, can file a lawsuit. So when it comes to actually defendants, it's typically the physician, the hospital, sometimes the nurses, and sometimes the labs. But what you have to be careful of is, if you're a named individual in this lawsuit, you got to get your name taken out of there. And we're going to talk about that in just a little bit even more. So you can go through the whole discovery process. You can request documents. You can go through depositions. You can ask for depositions, and you can ask questions of the other side. And they may ask that of you. They may ask you for documents. They may ask you questions in writing. Then you have to respond back in writing. And they may even ask you to give a deposition. Usually, it's called venue. A venue is what court is that lawsuit in front of. remember, there's actually several levels of courts that are here in Florida. There's the county level, the state level, and the federal level. That's typically the three sort of courts that we have here. So you've got to take a look at where your lawsuit is filed. Typically, it's done at the state level. So that's how you know, well, that's what you're getting when you get a lawsuit handed over to you. One of the things that I would suggest if anybody ever does get sued is go through what's your best case scenario and what's your worst case scenario. And you got to figure that out with like a learned counsel, and maybe even perhaps talking it over with some of your peers as to what they see wrong with that particular situation that has arisen. So I would consult a good friend of yours that's a physician that would understand the scenario. I would consult the attorney that you have, and I would also take a look at whether it's being filed for like a nuisance value. Some people just file for the sake of just getting some money out. So there's actually strategies you can use to stall a lawsuit, to slow it down, or to accelerate it. So for example, if you know somebody got hurt during a particular procedure, and you know that their likelihood of recovery is really good 2 years down the road when they show up at in a witness stand, that'll look good for you. So there's actually ways to kind of stall the lawsuit. Then there's ways to also accelerate the lawsuit too. So you can go, depending on which side of the equation you're on, you can actually use those sorts of strategies. But understand your best case and your worst case scenarios. So the do's and don'ts of what happens after you receive the legal papers. If you get an intent to sue letter or complaint, just go and notify your risk management department. Typically, most places do have a risk management department. If you don't, go and notify your insurance company or your agent for that insurance company, and they should be forwarding your letter to the underwriters. And the other thing is, if you're self-insured, you're going to have to go out and get your own attorney. Now, if you under a medical malpractice insurance program, you would be entitled to having your own legal counsel. Now, those legal counsels are typically picked and chosen by the insurance company. So guess who the boss is of that legal counsel? The insurance company. So if the insurance company is their legal counsel, you're still not, I don't think you're still fully 100% represented. I think you actually have to have your own sideline counsel to help you manage that legal process. A lot of people don't follow this, but I'll give you a great example that happened in something like that. There was a medical malpractice claim. Both sides settled it out. In the end, it was basically said that no side did any sort of wrongdoing, but the physician side ended up paying the plaintiff some kind of money. Let's say it's like $100,000. So when that happened, as soon as there's a judgment where there's money being transmitted over, it's reportable to the NPDB, even though it's considered no wrongdoing. And then the NPDB, as it shows up in the NPDB, the National Provider Data Bank, they view it as some sort of wrongdoing. That's how it's viewed by the public. So you got to make sure that your name is not in that final settlement agreement. It is not in the final judgment. And that's why I think you get people like me involved in the process. And what you're going to do is you're going to have your insurance counsel do 90% of the work. And then a guy like me who would be your personal counsel, I basically just manage the case from the backside. Now, for your own records, make sure you keep your calendar marked, track your deadlines, and understand your deadlines and keep your own deadlines on the calendar. Because, sometimes these attorneys are overburdened, especially insurance defense counsels. They have a lot of cases in their bucket, and they're juggling a lot of stuff. And so track your own deadlines, keep in regular contact with them, and just get yourself extracted out of that lawsuit. The faster, the better. A lot of times what I'll do is I'll actually threaten the other side and say, there's no settlement if my client is still going to be in the middle of this. Otherwise, we're going to trial. And, a lot of attorneys do not want to go to trial. So, they will often let my clients off of the case. Next, let's talk about proving the case. What must be proven? So when it comes to actually a negligence count, there's 4 elements that the plaintiff has to meet. One, that the physician had owed a duty of care, which is usually the standard of care that is already out there. It's in your profession. Everybody knows about it. Everybody's kind of familiar with that process. Did you follow the standard of care? So, for establishing that fact, both sides will have to get their own expert witnesses to establish whether the standard of care was followed or not. And then, the second element is that there was a breach of the standard of care. So on the physician side, you're going to have an expert witness that's going to say you didn't breach the standard of care. You actually comported with it and you followed it. And then the third thing that they have to prove is that there was causation, meaning that breach caused the actual damage to the patient. So there has to be a linking of what went wrong and how it affected the injury on the individual, and that the injury had a harmful effect, meaning usually some sort of pain, some sort of further suffering, or some sort of financial loss that occurred. So remember, normal defenses that are usually documented in the file. Florida also has a comparative negligence provision, meaning that if there's more than one professional involved, they will look for comparative negligence. Is one practitioner, or maybe the hospital, or maybe the lab, is one person 10% responsible, the other one 40, and the other one 50. So there is a comparative negligence. We are a comparative negligence state. So they will assign the blame to each party that's a defendant in the case. As you go through this, you'll see that there will be pleadings and motions. First thing is there's usually a demand letter that the physician will receive. They'll receive a complaint. Then there will be answer and affirmative defenses that the physician will have to file. And make sure that your affirmative defenses are as wide and solid as possible. That's why I think having a second counsel will help shore that up. The other thing is you want to make sure that the discovery is occurring, that your lawyer is asking for documents, that they are deposing people, that they are asking for like interrogatories to be answered, that there's a thorough investigation being done by your insurance counsel. And then ultimately, if you don't find, if the facts and the law is in your favor, then what you're going to do is you're going to move for what's called a motion for summary judgment. And the motion for summary judgment is you're looking for a judgment from the court without having to go to trial. And somewhere along the way, the court is going to require you to go to mediation. Sometimes they do it before motion for summary judgment. Sometimes they'll do it just before a trial. So, but somewhere along the way, you're going to have to go to mediation. But keep in mind, 90% or better of the cases are settled. So, on rare occasion, they do go to a trial. I was talking to one particular practitioner where they just got handed a $3 million judgment, and their name was still on the actual lawsuit. They're liable for the $3 million. There is no insurance in that particular situation, and the physician is completely out of cash because they've been paying for all of these legal battles that have been going on for several years. And their name shows up on the National Provider Data Bank. So that's like the worst of all outcomes, and you want to avoid that. So what you try to do is you want to make sure that your name is extracted. You are no longer a named party in the actual lawsuit. And if you have a practice, make sure that it's only the practice name that settles the lawsuit, not you yourself personally. So what can happen at the end of the case? So here's the possibilities. Number one, either the case will get voluntarily dismissed, and that's usually through mediation process, or the case gets dismissed with prejudice. The court might find that there was no cause, no reason for being for that lawsuit being filed, and it may get dismissed with prejudice. It may come in the form of a summary judgment. It may come in the form of a mediation, or there may be a bench trial or a jury trial. Now, when it comes to actually professional malpractice lawsuits that end with a monetary payment, keep in mind they get reported to the State Department of Health and the National Provider Data Bank. You cannot avoid that. It's just a part of the game. That's how it is. That's why you always want your name pulled out of there. Did I go fast enough, guys? Okay, so now.
Just right.
Thanks, Joe. So now this is the illustration that I have, that I created myself, as to how long it takes for litigation to work its way through the court system. If everything goes on track and everything is on time and everything is timely filed, which it never is or rarely is, you know, a normal sort of a lawsuit will take about 2 years to work its way through the system. So keep in mind, you're in for a 2 to 3 year battle. And you've got to figure out how to get out of that sort of a situation. So, you know, get yourself a calendar, you know, get yourself a nice drink on the side, and make sure you get a personal legal counsel, because you're going to go through cobwebs that you're not going to understand on your own, and you're going to need somebody to help you figure that out. And you may even want to bring on a physician that's helping you think through the situation as well, because that always helps. So with that said, any questions? I believe we're at the end of the presentation.
You have a question?
Sure.
Hear me?
Yes, I can hear you, Louis.
So I'll give you I was talking to a colleague of mine who was an
Wait,
OBGYN.
hold on, Louis, one second. Charles, can we stop the recording?
Yes.
I just don't want.
Let me just sign off for a second. Okay, I want to thank everybody for joining us tonight, and this will be posted on the South Florida Hospital News website within a couple of days, and we will see you in about 30 days for the next one. Thank you for joining us.